Hello and welcome back for the continuation of the topic on Kashmir. So, as we ended last class on the issue of Article 370, and as I referred to, the Article 370 was the result of uh, the participation of interim government of Jammu and Kashmir in the Constituent Assembly of India. So, interim government of Jammu and Kashmir led by Sheikh Abdullah. Uh, Members of the government participated in the constitution making process of the Indian Constitution, and thus the Article 370 was drafted. And uh, the name is very illustrative of the fact why the provision was brought about and the nature of the provision. So, Article 370's title is transitional and temporary. So, even for the people of Kashmir, they had no problem considering it as a temporary provision. They did not envision it as something uh, as a permanent feature of Indian Constitution. They also assumed that when the right time comes, there will be full integration. There will be no exceptions, or they will, and the citizens of Kashmir or people of Kashmir will be treated equally. Of course, in 47 itself, the provisions were such that they would be treated as equal, but there were exceptions. Like I discussed earlier regarding the subject matter jurisdiction, there were exceptions, and then Article 35A brought in certain exceptions. So, considering this, the exceptional scenario in which the state got integrated to the Union of India, it necessitated the enactment of Article 370. Okay, so as I suggested, or as has been pointed out, that the title of the article is transitional and temporary. Be mindful of these two words. Transitional means it is for a particular period only. It is just an interim article. The name itself illustrates this fact. When we say something is transitional, we mean that it is for a intermediate period, like we are shifting from one position to another, then the interim period is known as transitional period. So you can say Article 370 had an use. What was its use? Its use was to create an arrangement so that the full integration of the state of Jammu and Kashmir is possible with the Union of India, which has now constitutionally as well as legally been made possible through the events of 5th August 2019. So here it was held in the Article 370, it was held that the final integration will be the final integration of the state of Jammu and Kashmir will be decided by the will of the people. Will of the people, or more specifically, the representative who represented the will of the people. That the Constitution itself defined it as the Constituent Assembly of JNK, which I pointed out in our last class that it was dissolved in the year 1957. So there is a twist to it, which we will come to later. But now moving directly to what the article says, the remember the fact that the directly elected Constituent Assembly of Jammu and Kashmir ratified Article 370. It ratified the Article 370. So what we should be very clear the salient features. The salient features of Article 370. So, the first feature that is significant is that the Constitution of India will apply in Jammu and Kashmir with respect to Articles 1 and Article 370 only. It means that other than Article 370 and Article 1, other provisions of the Constitution will not be applicable directly to Jammu and Kashmir. So this was the first provision, and it is also, be mindful, when we say that Article 1 is applicable, what does it portray or what does it refer to? It refers that Jammu and Kashmir is an integral part of India. So there should not be any doubt of this fact. There has been separatist demand like the Hurriyats, and there has been tendency among certain academic circles to think about such a think on those lines, which suggest you can say independent existence of Jammu and Kashmir. But clearly, adherence to Article 1 implies that Jammu and Kashmir is an integral part of Union of India. And besides this, the first fact that Article 370 says is that Article 1 and 370 are applicable to Jammu and Kashmir, or are the only two articles of the Constitution applicable to the state of Jammu and Kashmir directly. It further states three things. The first thing that it states is that how Article 370 can be amended. How can it be amended? It says that it can be amended. This is specifically given in Article 370, Clause 3. There it says that a presidential order, like I referred to before regarding the 1954 presidential order, which brought in Article 35A. Similarly, if a presidential order is brought about, which is recommended by whom? By the Constituent Assembly of Jammu and Kashmir, which has supposedly been dissolved. Originally, it was elected in which year? I gave you that timeline, 1951, the direct Constituent Assembly of the Jammu and Kashmir. But it dissolved in the year 1957. So, actually, many argue this fact that the dissolution of Constituent Assembly of Jammu and Kashmir makes 370 Clause 3 redundant, because since there is no Constituent Assembly, so there cannot be a constitutional way of dissolving or abrogating 370. But there is a catch to it, which we will discuss later. So, what it essentially says is that 370 itself provides the provision for its own demise. That is how it is through a presidential order on the recommendation of Constituent Assembly of Jammu and Kashmir. That is what the law says, or what the Constitution says. Secondly, like this will be the third. The thirdly, what does it say? What is the extent to which other provisions of the Constitution of India applies to Jammu and Kashmir? As I alluded to with reference to instrument of annexation, the three subjects of defense, foreign affairs, and communication are exceptions on which Government of India or Union of India will have the full power. But other than this, there are various subjects in union list, various subjects in concurrent list, which the union government should legally be in a position to make law. Parliament should be in a position to make law, but that is not applicable for Jammu and Kashmir till 370 was there. So it 370 also highlights the fact that how other provisions, means other than these three, how other provisions of Constitution of India will be applicable to the state of Jammu and Kashmir. So what is the way? So here again, the union government through a presidential order can extend the provisions provided under instrument of accession, means those subjects given under instrument of accession. What are those subjects? As I referred to this. So to apply these things or to make law or to execute certain actions with respect to these subjects, what is the procedure? The procedure is pass presidential order, and here only the consultation is required with Jammu and Kashmir Legislative Assembly. But if you are trying to apply or you are trying to extend other provisions, means if you are trying to implement something beyond the instrument of accession, the subjects which are beyond the instrument of accession. Okay, so for those subjects, what 370 says is that yes, union government can do it, but provided there is concurrence. Concurrence means agreement. Concurrence of Jammu and Kashmir Legislative Assembly. So see, there are ways of bringing in laws in subjects which are excluded under instrument of accession, or which instrument of accession doesn't cover. But for that, presidential order can be passed provided there is concurrence of the assembly. If assembly concurs, then matters of union or concurrent list beyond these things also can be implemented in Jammu and Kashmir. This is the second fact regarding Article 370. Then thirdly, what Article 370 says is it gives or it defines the power of Parliament with respect to Jammu and Kashmir. So as I referred to, Article 370 limits the enactment of laws of union list, like generally Parliament has the authority to make laws on union list and concurrent list also. But with respect to Jammu and Kashmir, this power is limited to defense, communication, and foreign affairs. But if Union Parliament desires, then for other some subjects also it can do it, provided there is concurrence of the Jammu and Kashmir Assembly. So again, you should be appreciative of the fact that India is a asymmetric federation. So some people are of the opinion that exercise or abrogation of 370 is a violation on Indian federal structure or violation of federalism. But here you should you can put forward this argument that India is not a symmetric federation. Here we have a symmetric federation, means relation with all states are not same. So appreciative of the different diverse circumstances that different states faces, so our nature of federal relation changes. So these are briefly what 370 says. So what can you what is the understanding that you can carry on from 370? Is 370 an insurmountable barrier for union government? Answer is no. Even if 370 would not have been abrogated, yet it still created ways through which the subjects of union government or other provisions of the constitution could be funneled in to the Jammu and Kashmir. And it is, you should know this fact that even before August 2019, right since 1950s, 60s, there through backdoor, that means through presidential order, through certain judicial machinations, judicial tactics or legal tactics, many provisions have been applied to Jammu and Kashmir. So in this context, our former Prime Minister Guljari Lal Nanda, he referred that, he made a statement, you can note it down. He said that Article 370 is neither a wall nor a mountain, but a tunnel which through which we will export almost all parts of the constitution. So this was said by Guljari Lal Nanda in the 1960s itself. So although it has gained a lot of political mileage, because abrogation of Article 370 has been one of the important planks of BJP's propaganda, electoral propaganda. But you should, as a student of polity, be appreciative of these technicalities, of this fact that Article 370 itself provided for its demise. Article 370 itself provided for tunneling of India's constitution. It had ways through which you could have brought in India's constitution through 370 itself. So that is the significance, that is the understanding that you should carry forward. And remember what happened on 5th August 2019. That was not the only way through which it could have been made. Actually, what happened was that, or what were the options available for the government, union government? Actually, government could have exercised 368 also, because 368 gives power to the parliament to amend. Of course, it will require special majority, but it gives power to the parliament to amend any part of the constitution. So that way, through the use of 368, you could have abrogated 370 or changed the meaning of 370. But government used, or parliament used, 370 clause 3. That is, through a presidential order on the recommendation of Jammu and Kashmir Legislative Assembly. Here again, there is a catch, because earlier it was Jammu and Kashmir Constituent Assembly. This is one of the changes brought in on that day itself, where the definition part, Article 367, has been changed, where the terms Constituent Assembly has been replaced with the word Legislative Assembly. That is perfectly legal, perfectly possible to define it in that manner. So that is what 370 is all about. Now, so having appreciated the features of 370, you will now appreciate certain events. Like in 1965, the union government was able to make amendment to the constitution of Jammu and Kashmir itself. Okay, so there earlier governor of Jammu and Kashmir was to be appointed by the assembly, the Constituent Assembly of Jammu and Kashmir. But in 1965, this was changed, where the governor will be appointed by the union. And when Council of Ministers do not exist, then through the governor, the majority of provisions of the Constitution was extended. Actually, this was 2019 also, same thing happened, because there was president rule going on. So once you have the governor, and that is why the role of governor has been very controversial, or it has been a game changer for the union government. And here we have to talk in non-partisan basis, because be it BJP, be it Congress, and the governor has played a, you can say, pivotal role in making political changes in Kashmir. So in 65, what happened was the process of the appointment of governor was changed. So governor's appointment could be made by the union. And second important fact is that first is union appoints governor, that power had been taken by the union. And second is that when there is no council of minister, then through the governor, then governor will act as a de facto head of the state. So through the governor, the majority provisions will be extended. So this was the case. Now, looking at the latest development, the 2019 was not a standalone event. There were developments happening since 2015. In fact, if you remember, if you can recall, in 2015, there was this alliance of BJP. First time BJP had a government, was participating in government formation in Jammu and Kashmir. So BJP along with PDP, Mehbooba Mufti Mohammad Said's daughter. So that party, this alliance was formed between BJP and PDP, and this government was formed. But then 2016, certain events happened, like Uri, Pathankot, Gurdaspur, all these events happened. So in 2018, what happened? BJP pulled out of this government. Pulled out. So when BJP pulled out, so according to Jammu and Kashmir Constitution, has the provision of governor rule. You will not hear governor rule for any other state. Everywhere you will hear president rule. But Jammu and Kashmir Constitution has the provision of governor rule. So for 6 months there was governor rule, and later after that there was the president rule. So June 18 to December 18. June 18 to December 18, there was governor rule. Then since January 2019, still it goes on. There is president rule. So at the national level, what happened in May 2019? BJP comes back to power. So with a renewed majority, so on 5th August 2019, as I referred to earlier, through exercise of Article 370, Clause 3, presidential order, actually two presidential orders were brought about. First was Presidential Order 272. 272, application of Constitution in Jammu and Kashmir. Application of Constitution in Jammu and Kashmir. This was the presidential order. So now remember instrument of accession, remember 370. So to make such a provision applicable, you need what? You need not consultation, but concurrence of the Assembly of Jammu and Kashmir. Now, how was this concurrence to be gained or to be taken? Through the governor. So governor gave concurrence. It was assumed that our constitutional scheme is such that under such a scenario, governor takes the role of the assembly. So governor gives concurrence that is equivalent to the assembly giving concurrence, and so the presidential order, actually what it did, its effect was that it abrogated the presidential order of 1954. What was brought in by presidential order 1954? Article 35A. What was 35A? It created the provision, or it empowered the Jammu and Kashmir Legislative Assembly to define permanent residence of Jammu and Kashmir. So now there would be no such special treatment or no such possibility of special treatment for people of Jammu and Kashmir. They will be, or in a way you can say, they will be fully integrated to the Indian Union. So all the provisions of the constitution are to be extended, and Article 35A gets automatically abrogated. So through this presidential order, this is the effective change. If in interview you are asked what was the change that is brought, it was brought about by the event of 5th August 2019, then you have to say that all provisions of the Constitution of India was automatically extended, or you can say was extended to the state of Jammu and Kashmir. And of course there was this Jammu and Kashmir Reorganization Act that made it a union territory, but that is a temporary provision. Obviously, in very near future, it might get, or it will definitely. Government is what we are hearing from policy circles is that statehood will be restored very soon. There is no debate. Actually, in Parliament, the Attorney General was talking in those lines. Sorry, in the Supreme Court, because Supreme Court has been hearing petitions on abrogation of 370. So there has been statements like that. And I hope I have mentioned this fact that in that one of the hearings, the Chief Justice of India, Mr. D.Y. Chandrasud, he specifically said that the fact that what happened in 1947, there was like the signing of instrument of accession on 26th October 1947. That was not a conditional surrender of sovereignty to the dominion of India. It was a complete, you can say, complete integration. Or what he says, Chandrasud says that it was no conditional surrender of sovereignty to the dominion of India. It means Jammu and Kashmir did not put any condition. Their surrender was complete, or their integration was complete. Surrender seems to be a very, you can say, harsh word. It appears that somebody is subordinate, so they are surrendering. But if you consider it in a different light, then you can appreciate this statement better. So what he says is that there can be no question on the sovereignty of Jammu and Kashmir, or the fact that they had totally given up on sovereignty. Sovereignty means their freedom, or their willingness to exist as an independent entity was actually beyond reasonable doubt, or beyond doubt, when the instrument of accession was signed. So taking that into consideration, the changes that has been brought about by 5th August 2019 actually, in a way, makes these things very explicit. These things were already implicit, but this has been brought explicitly by the events of 5th August 2019. Now, as I referred to, the presidential order of 2000 of 5th August 2000, the first presidential order, what was it related to? It was related to applying the provisions of constitution to the whole state of Jammu and Kashmir. Then certain other changes were made, like Article 367, which has interpretation. Actually, the title is interpretation, or uh, giving new meaning or definition. It's kind of a definition. So here certain provisions were added or amended only for the state of Jammu and Kashmir. So here what in clause 4 of this article, when it says constitution, so here it says the constitution in clause 4 of 367 means the constitution as applicable in Jammu and Kashmir, and constitution as applicable in Jammu and Kashmir means it is removing all the possible legal roadblocks that can come for the move. Then when it says government of state, so government of state can be equated with governor. So when the state or assembly is suspended, or when the state is under president rule, then government of state can be equated with governor. And thirdly, and most importantly, constituent assembly can be equated with the legislative assembly. And this is a very practical thing, because otherwise Article 368 would not have been given by the constituent makers, because they presume that at certain scenario the future assemblies would have to act as a constituent assembly. That is why you have Article 368. A similar spirit or similar sentiment can be interpreted with respect to Jammu and Kashmir also. Because 370 clause 3, although it said that only through a presidential order which has been recommended by the Jammu and Kashmir Constituent Assembly can be create the conditions for abrogation of 370, but since assembly has been dissolved in 1957, so practically it is not possible. So should we just stop it? No, because again, see, you have to read the constitution in a harmonious manner, because on the one hand you are putting the title as temporary and transitional, on the other hand you are taking the certain legal loophole to assert that no, this is a permanent provision. That creates, you can say, disharmony. So when you are trying to interpret something, you appreciate it, or you try to interpret it taking the whole constitution as one. Take help of other interpretation, take help of other articles. So here the title actually helps us understanding the fact that no, the 370 is not meant to be a permanent feature. It is a transitional feature. So that way, this has you can actually support this argument. Again, it is now, because it's a matter of judicial interpretation, there things might change, but what is there, that you should have a clear idea. So 367, it changes, and the changes brought about in 5th August 2019 also brought changes in 367, which has changed interpretation or amended certain interpretations, wherein number one, constitution, when we refer to it as constitution, with respect to Jammu and Kashmir, means constitution as applicable to the state of Jammu and Kashmir, and government of state means can be equated with governor, and similarly constituency. Then there was this second presidential order 273. So what was it? It was basically amendment of Article 370. So here it was through a resolution of the parliament. Now, because the state assembly was suspended, or it was under president rule, so recommendation of constituent assembly will not be applicable. Now Jammu and Kashmir Legislative Assembly will be actually represented by the governor. So based on that, you amend Article 370 based on recommendation of the governor. So as per 356, what does 356 say? 356 says that when any state is under president rule, the power of legislative assembly is exercised by whom? By the Union Parliament. Union Parliament directly exercises the legislative power when the state is under president rule. So here, either directly it does it, or through certain authorities appointed by it. Now, so here, so what does the second presidential order bring about? It brings about amendment of Article 370 directly through the recommendation of the governor, practically governor or on governor on, that means parliament on behalf of the governor. Okay. So governor recommends it and parliament has amended it, amended 370. First, presidential order, extension of all constitutional provision to Jammu and Kashmir. Second presidential order, amendment of Article 370. So right now 370 is still there, but it has been made redundant. Okay. So 370, what is the shape of 370 right now? The shape is that all provisions of constitution will apply in Jammu and Kashmir. That is the current shape. So currently, if you are asking, is 370 removed from the constitution? Answer is no. So currently, Article 370 looks like what? It looks like all provisions of constitution will apply in Jammu and Kashmir. Okay. So summing up, on 5th August, actually 4 things happened. What are the 4 things that happened? Number 1, Presidential Order 272. That means it abrogated, first thing, it extended the provisions of the constitution, and it abrogated the 1954 presidential order. So 1954 presidential order abrogated, so automatically 335A got removed, or it was no longer applicable. Then rest of the constitution, means earlier only Article 1 and 370 were applicable. Now rest of the constitution will be extended, and amendment of Article 367. Okay. And Amit Shah, the Home Minister, he brought in 2 resolutions in Parliament. First, again, for the amendment of 370, that is the second presidential order, and where it was said that Legislative Assembly, because it was under President rule, Legislative Assembly will be, the power of the Legislative Assembly will be exercised directly by the Parliament. So that was another, the second order that was brought about. And fourthly, this was the second. This was the third, was Presidential Order 273, which amended Article 370. And fourthly, the Jammu and Kashmir Reorganization Bill, which obviously, which article will it relate to, or what article will it draw power from? Article is Article 3. Here you know it is not under Article 368, because there in such a scenario, Union Parliament has the authority to change the name, change the shape. As we should have this understanding of Article 3 and 4, how it gives power to the Parliament to actually change the territory, change the name of any state, change the boundary, change the nature of any state. So there the states do not have any say. So these 4 things were brought about by the changes on August 5 and August 6 also. So August 5 and 6, these changes were brought about. I hope you are clear with all these things. In the next class, we will discuss about the 3 grand strategies with respect to the state of Jammu and Kashmir. What has been the grand strategies since independence? And then we will look into other states. Thank you.